SJC-11480, Commonwealth v. John Rex.
Good morning, Your Honors.
Please hold on 1 minute. We want to get you on tape. And Mr. Keneally has to, okay, we're on the record now.
Good morning, Your Honors. Varshy Kukafka for the Commonwealth. With me is Assistant District Attorney Ann Yaz, and I will reserve 2 minutes for rebuttal. These 7 indictments for child pornography were properly issued, and they should be reinstated. There was probable cause to find that these photographs were lewd images, and that is the purpose of the grand jury, to make that assessment in a common sense manner.
Let me just see if I understand this. If these photographs were in the possession of a good person, someone who was not a prisoner serving a very lengthy sentence for sex offenses, just a person, they would be not child pornography, but possessed by someone like the defendant here, they are?
That is not at all why the indictments were brought.
Well, I mean, I'm talking about the photos, whether they constitute child pornography. Is it true that they wouldn't constitute child pornography if they were in the hands of someone else?
These 7 photographs, as is in the possession, not in the possession of, but in that envelope, those that stand alone are considered lewd for purposes of probable cause at this stage, and the indictments should be reinstated. Whether a particular photograph, in the context that it was at one point for a serious educational or artistic purpose, that is another question. That is not the question before this court. The question before this court and all of the cases that deal with whether an image is lewd are post-conviction for a very good reason.
I understand that, but what I guess my question is this. Let's assume someone who was not a prisoner, not a sex offender, cut out these same photos and had them in an envelope in his or her desk drawer. Would you say, well, that's child pornography?
I would say it is possible that charges could be brought with these same, what he called his collection, that yes, I would say, because they are the same images.
So we should put people on notice that they have to be very careful about what they cut out of magazines that are otherwise not child pornography. They can become child pornography if assembled in a certain way?
It's not the assembling. It's not necessarily the collection. It's the severing from the original legitimate purpose. And if you go back to Ferber, the United States Supreme Court was already talking about this in some of the concurrences. If there was a film, but there was one section of the film that when isolated could be lewd. And that's what the recent case in Stewart that I provided in a 16L, that's the Sixth Circuit case. And since I sent the 16L letter, certiorari was denied. That was talking about cropping photographs, using a brightening or a heightening of the little girls on the beach that were swimming and taking those and doing something to them.
All right, so, but here we don't have anybody enhancing things. We just have cutouts.
Well, we have, yes, we have a change of use, a change of image, really, because this defendant did not have, he did not have a National Geographic, an issue of National Geographic. He did not have an article from National Geographic. He did not have the page of National Geographic that had this photograph, and he did not have the photograph that was in National Geographic. What he had was the tiny little portion of that photograph that shows a nude boy with his penis exposed. He did not show the background. He did not show the other person in the photograph that was clothed, that was beside him. And the whole context.
Actually, that's a point. Can I ask you? There was no context. What remains of the photographs that I viewed that were exhibits, there was no longer a context. There wasn't certainly the context there used to be, but in this case, there was also no context. Young boy standing there, penis exposed. Young boy, young girl together. So what are you, if you take out the context, even assuming your argument, but just for the moment, what context do you imbue these cutouts with? There's no behavior that suggests anything, it's just standing there.
Well, because they are completely nude.
They are.
They are either frontally nude or from the rear, but they're pubic areas, and most of them have the genitals.
They're all nude. Right?
Yes. And they are, and that is all that's in the picture is the child, the nude child. So I think what Your Honor is asking is, doesn't there have to be more? Well, no, there doesn't have to be more
is
because
that?
lewd means it's a layperson's understanding of what lewd is. It doesn't have to be, a formula to show that there is something. It doesn't have to be overt sexuality or sexual activity in the photograph.
Well, should we be charging National Geographic with being a purveyor of child pornography?
No, obviously, absolutely not, Your Honor, because when they show a nude child, it is usually in a group, usually it is for the educational purpose. It is part of an article instructing or talking about a culture where this is normal.
But where, as a follow-up to that, where National Geographic hasn't exploited the children in taking these photographs, exploited them for sexual purposes, and I think that our court has said that really is the purpose behind the legislation. Where the original purpose has not been exploitive, but the cropping or the subsequent use of certain portions of the photograph might be exploitive. Doesn't there have to be some kind of amplification of like the identity of the child where it wasn't originally exploitive?
No, because you'll see in Ferber and in other cases where they talk about the broad purpose of child pornography statutes is to protect children and the community. And these photographs are used, they're not only exploiting a known child at the time the photograph was taken, but they are used then, as obvious in this case, for purposes of either a clandestine, use of them or to use them for new future victims,
So
to show that to them.
If the person who was holding these cropped photographs had cropped it to the point where the only subject matter in the photograph was the genital area of the child, is that a violation of the statute?
Yes, that could very well be. The Stewart case, there were croppings from that group of the children on the beach. Some of them were croppings just to focus on the genitals, and other ones were brightening or highlighting that area of the child. But it doesn't have to be, when it says the focal point, and again, the DOS factors are just probably helpful. They're not necessarily have to be used or are used, but the focal point is one of them. And so in this case, you could say that the focal point is the genitals, even though you see the child's face, because it is, the entire picture is this nude child.
Maybe I misunderstood one of the answers you gave to Justice Spina. Are you suggesting that the intent of the possessor can make the photograph pornographic even if it wasn't taken with that purpose or intent and wouldn't be pornographic in context?
Well, that is one of the factors in DOS, which is number 6, which can be used if it was intended to be used for that purpose.
So if a National Geographic photo is cut out by someone who finds it sexually stimulating, then it might be pornography, whereas if someone cuts it out because they find it really an interesting cultural thing, then it wouldn't be?
Well, it depends how they find it interesting culturally. Do they find it interesting by taking a tiny little 1-inch section of the nude child with his penis exposed? Is that interesting to them? Or do they take the entire photograph of this tribe?
So it is the intent of the person who has the photo that determines whether it's lewd?
It's not just intent, but it's actual what is the image before you? And if you look at these images, you will see there is nothing, and I think it was the Ferber Court or maybe the Fabrizio Court, the First Circuit, which talked about there's nothing indisputably innocent about the setting. And that's important. I mean, Fabrizio is important because it's really the only case where this issue was talked about pre-trial. And it wasn't in a motion to dismiss under a probable cause standard, but it was a motion in limine to exclude 3 of the 19 photographs. And the District Court of Massachusetts said that the 3 were not lewd, and the First Circuit went back and said absolutely not. And they talked about the DOS factors and the reasoning, and they talked about the fact that when you're talking about, oh, nudity alone is not enough, that normally refers to an infant, a baby. Normally, that's acceptable, a baby in the bath, a baby on the rug, these kinds of things. But when you get into the prepubescent and the adolescent, or anything really over that age, not that people couldn't use nude photographs of an infant for their own gratification, but the fact that the harm is to the child.
So if an entire page was removed from a National Geographic issue, and one of the objects depicted in the page is a child, a naked child, somebody could possess that entire page that was created, a photograph that was created purely for cultural purposes, and if you could establish that the person's intent was to derive sexual gratification from that entire page, that would be possession of pornography.
No, I would not say that. I would say we would not have charged that as child pornography, because it's a page, but it's in, at least in a context, and it's other people. You can see from these, and the court I know has the other examples from the nudist brochure, that these tiny little pictures were cut away from all the adults.
What if it was just folded that way? You have the whole page, you don't get scissors in jail, you just fold it up so that that's what you see.
Well, again, it sounds kind of an extreme. There is prosecutorial discretion, and we're not saying that because that is.
This person did that. Let's say it's this person, this defendant, has a bunch of all these things, except he doesn't have scissors. So he just folds them up.
Well, that's not what it is. And
Well, I'm trying to test how far this goes, your premise. It's focusing and getting rid of context. So
It's
it
getting
doesn't
rid
have
of
to be by
context.
scissors? Can it be, what if he has a little square cardboard and just I mean, you know.
well, there's a whole range of, there's a whole continuum of what it could be, but that is not what it is. I will say, too, that in terms of this, it's important, and I see the light is on, but the grand jury stage, that the Commonwealth did not know where these things came from and is not have a burden to go and post an ad in the paper. Does anyone know where these came from?
If I can turn you, I'm sorry, Chief, just one more question. If it's not lewd, there's a First Amendment right to possess it, correct?
Yes.
And should the McCarthy standard be the same when there's an issue of whether or not you are going to be charged with the possession of that which you might have a First Amendment right to possess?
Yes, the McCarthy standard should be the same. It's a question for a jury, and all cases have said that. It's a question for a fact finder.
Even though a judge may find as a matter of law that it would not be lewd and lascivious?
Yes, because the basic question is a question of fact, just like it analogous to a dangerous weapon as used, a simple take a book and beat someone over the head. That is a question for a jury, just like this one is, regardless of the First Amendment issue. And I would reserve 2 minutes.
Good morning, Your Honors. Bruce Carroll for Mr. Rex. I have to say that I would agree with Justice the gist of Justice Cordy's questions. It's a good starting point, I think, for the discussion here. If I'm at home with my 8-year-old child or my 10-year-old child and working on a homework assignment, show us the cultures and the countries that use bicycles for means of transportation, and I sit with my 10-year-old son and cut out that picture and only use half of it because of the limitations on my homework assignment and put it on a piece of schoolwork, am I going to be charged with possession of child pornography?
But let us take the opposite, though. Let's take these photos, which are not identified, right?
I'm sorry?
The photos are not identified.
Correct.
Let's say you put them on your computer and sent them to a pedophile saying, wow, look at this. This is awesome. Would that be sort of transmitting pornographic material?
Only if it's pornographic to begin with. And if it's not pornography to begin with, then it's not transmission.
But we don't know anything about the origination of these. All we know is that they are naked children with their genitals exposed.
And if nudity by itself is not enough to make something lewd and make something lascivious, then you have to have something more than mere nudity to get to that step.
But it may not have been enough in the original photograph because of the context that was generated in the original photograph. But once you eliminate that context, you may have something that's a lot more problematic.
Well, but if you look at each photo as itself, and what's important is the depiction, not where the depiction is being held. What's important is what's actually depicted in the photograph. And when you take a picture of a naked person head on, straight on, you're going to see the genitalia, whether it's an adult or a child. And the question is that enough to be pornography? And pretty much universally, I would suggest the answer to that historically has been no. Nudity is not enough.
So if these persons, these children, had been brought into a room by someone who was in the business of selling pictures of naked children and photographed, and but they look just like these photographs and were sent out over the internet to websites that catered to pedophiles, we're still saying, well, it's only like a naked person, therefore it's not child pornography.
But in a straight, if you're talking about intent, you're not talking about straight possession anymore.
Okay.
Now you're talking about dissemination or production. And I don't think intent enters into a straight possession case. The object speaks for itself, so if you will permit me to say that. And what the observer takes from the picture can't be the criteria we use to define pornography. In preparation of this case, practically since I got it back in 2011 or 2012, I've used the analogy, when I look at the Olympic rings, I see 5 circles intertwined and meshing with each other. Somebody else with some sort of odd predilection may see a depiction of group sex. And it can't be who's looking at it. It's either pornography for everybody or pornography for nobody. It can't be pornography in Mr. Rex's hands if it's not pornography in my hands.
Is it your view that the taking of the photograph has to be sexually exploitative?
Sorry?
Is it your view that the taking of the photograph has to be sexually exploitative for it to be lewd?
Well, I think there has to be some suggestion of exploitation in the photograph. Just taking a picture, there's no exploitation. These particular...
Certain photographs would be exploitative. Obviously, the person's being asked to pose in a certain fashion.
Right, but we have no suggestion in any of these pictures that anybody was asked to pose. Some of the cases talk about, taking a child, lying them on the bed, opening their legs, spreading their legs, and then taking a picture. You've done something to manipulate the child in that situation, and you've done something to create something more than just mere nudity. The focus really is then on the genitalia. So that, I think, how you differentiate it.
Okay, but your sister seems to take the view that you can have a non-sexually exploitative photograph, say taken by National Geographic, and by cropping it, transform it into a lewd photograph.
Well, again, Mr. Rex is charged with possession of the photograph, not with the production of the
Well, I know, but I mean,
cropping.
but she would say that if it is cropped, even though it was not exploitative in its creation, it essentially, I guess, became exploitative in its possession through the cropping of the genitalia.
Well, I would suggest that it not exploited because the children who are depicted in these pictures weren't exploited in the first place. There's a picture from the National Geographic that shows a young boy picking up a bicycle as if he's getting ready to ride away. There's a picture from the sociology textbook that shows the context of that is there were like 4 or 5 different young boys standing looking out over water. They're not being exploited in that situation. I'm sorry the book itself didn't come, and it was introduced at the motion to dismiss, but I noticed in the exhibit the actual textbook is not here. But those children were not being exploited. They were simply, and the same is true with the Naturist magazine internationally. These are children who are in the midst of families, adults. They're doing everyday things. The only thing that differentiates them from my doing them out on the lakes of Maine or something like that is they happen to do it naked and I do it in a bathing suit. So there's nothing exploitive going on when the pictures are taken. So if the intent of the legislature was to make sure that we didn't exploit children and didn't subject them to sexual abuse, if there was no victim, quote unquote, in the initial picture taking, there's no victim today in the crop picture.
So in my earlier question, if you could blow this perfectly legitimate picture up, crop out the picture of the child, and blow that up to the point where you could recognize the child and identify the child by name, that really wouldn't matter in your view because the original creation of the photograph did not exploit that child, and it's only being possessed by this person.
The child, I can imagine, might be embarrassed if the child sort of knew or came to know that this picture was being circulated in a magazine or came into the possession of somebody in Massachusetts who cut it out and put it on their coffee table. But it's not exploitive in the sense that no child has been subjected to any sort of abuse or sexual activity or anything of that nature. If nudity is not enough, and we know it's not, then even no matter how big I blow it up, if I blow it up and put it on the wall at the Museum of Fine Arts, it doesn't make it pornography. If I blow it up and put it on the wall in my bedroom, it doesn't make it pornography because it's still just a naked child.
So you say nudity is not enough, and I know that's a phrase that we see.
sorry, Your Honor.
Nudity is not enough. Okay, so nudity plus what?
Well, the case law seems to suggest that at least there has traditionally that it has been suggested that there be some sexuality or eroticism or things of that nature. And none of these pictures get to that point. And Justice Kaplan makes that very clear. There's nothing sexual about any of these portrayals. They're simply people in natural settings doing what people do every day.
So that would be one, sexuality or eroticism in the photograph. What about if these photos were taken by someone who had the intent, a lascivious intent, and essentially intended to use them as child pornography? Would that be a plus, or was that not
Well, I
relevant?
don't think you can transfer the intent of the photographer to the viewer, especially if straight possession there's no intent. So while the photographer may have intended to create something erotic, if there's nothing objectively erotic or sexual about it, then if it's in my hand and I look at it and say, well, this is a nice picture of a naked child.
But if the photographer took it for the purpose of, okay, this would be sale, that's true, for the purpose of abuse. I mean, you say in National Geographic, these weren't taken with any purpose to exploit. And I'm asking you, well, if it was taken with a purpose to exploit, would that be the plus that went along with nudity?
I don't think so, because you can't assume that the viewer knew what the photographer's intent was. If I'm the photographer and I'm taking a picture of a naked child and I plan to disseminate it because it may turn somebody on, it may not turn everybody on. And the question isn't whether or not it excites the recipient, or not, because one recipient may be excited and the next recipient might not be. You have to be able to look at the image itself and
you're
not think about what the intent of the photographer was.
So you're saying everyone would know it if they saw it?
I'm not quoting Potter Stewart. I think he was the one who said it, at least initially and most famously.
But your view is that it is a judicial determination that must be made from reviewing the photographs themselves. You're saying that it is a judicial determination that can be made from looking at the photographs themselves.
Well, I think in the McCarthy context, yes, because one of the things that McCarthy teaches us is that the Commonwealth has to establish probable cause for every element that's alleged in the crime. And in this crime, it has to be a lewd exhibition or somehow lascivious. And when you're dealing with constitutional rights like the First Amendment here, the idea of de novo review, if you will, by a Superior Court judge or an appellate court panel, we know that that's done. We know that because we've seen cases like Bean and Oakes and things like that. While they may not be McCarthy cases, they may be more Lattimore required finding kind of cases, we know that the courts are willing to involve themselves in de novo review to determine whether or not the images, in fact, are pornography or not. And in those kinds of situations, we know that appellate court panels will say, we've looked at this, this is not pornography, we're asserting our position over that of the jury who convicted. And I think that's important when you're talking about fundamental constitutional rights like the First Amendment.
So your view is that with a probable cause doesn't matter. It either a judge looks at it on a McCarthy motion and says it is or is not, and if it is, it's protected by the First Amendment and you can't charge the person with it.
If it's protected by the First Amendment, it shouldn't be. No citizen in Massachusetts or in New England or the United States should have to worry about whether or not they're going to be arrested or not or indicted or not for possession of pornography for having these images in their home, whether they're cropped or not, because it's protected conduct under the First Amendment. If there are any other questions, I'm happy to address them. I would say that on this whole intent issue, I think the Commonwealth tried to sort of get the grand jury to think about intent because that had to have been the purpose for its introduction of things like the teddy bear, the drawings. Those are basically irrelevant to a straight possession case. Again, it goes to what they're trying to get the grand jury to think about what Mr. Rex's use of those items were. The teddy bear, his letters to his parents or to his friend about his being in trouble, none of that really speaks to whether or not the images themselves are pornography. All that speaks to is we're trying to get the grand jury to ignore what the pictures themselves are and think about who John Rex is and what might be going on in his head. And that's not a proper consideration on a straight possession case. So I would ask the court to affirm Judge Kaplan's decision. He was very careful about it. He went through the DOS factors. He went through the statutory factors. He found that there is nothing sexual about any of these, nothing erotic about any of these pictures, and that they don't meet the standard that have been set by the case law and the statutory law to meet the standard of lewd exhibition. Thank you.
Thank you, counsel.
Your Honors, the Commonwealth stands by that this belongs in front of a jury, not on a probable cause determination. But even if the court said it should be because it's a First Amendment issue, this judge made numerous errors, and his order should be vacated and the indictments reinstated. This judge applied extraneous materials that were not before the grand jurors. And I would agree with the court, the suggestion that if you took these very images and put them on a website, Little Boys or something, yes, they are child pornography, stand alone. But the judge went back and took things from the caption, from the textbook, or the picture of the one little boy standing sideways that was reproduced in image number 13. It was cropped again and reproduced a second time by the defendant to make like a dual picture with the boy on the bike. And so the judge says, this is from a Christmas party. Well, that is not what this defendant had. He didn't have a picture of a group at a Christmas party. He says that the picture, I think it's 11 of the boy and girl, this is a brother and sister, nothing wrong with that. There's nothing before the grand jury that says this is a brother or sister or father with his
Let me ask you
children.
this. Is it your view that there's probable cause to believe that any of these photographs were exploitive of the children who were photographed?
Yes, there is, but that's not the burden of the Commonwealth. But yes, there is.
Not the burden, so therefore you can have, it can maybe lewd and lascivious even though the child himself or herself was not sexually exploited in the taking of the photograph.
Well, I'm not saying that they were not sexually exploited taking the photograph, because the photograph's now for sale anywhere, and this little child that's 6 or 7 or 8 years old doesn't necessarily want this picture of themselves blasted all over the world. So they don't have control over that. They're a young child of tender years. So we're not
So
saying
that goes back to whether the Chief's question, whether National Geographic is a purveyor of this, since it is.
No, not at all. That is in that society, in that context, they're not showing a child that, you know, was taken away from his context and put nude. He's just normally doing something. So they're not purveying anything wrong. They're just showing a different culture. He's cut away. Even the sky and the sand in the nudist brochure is cut away, so that you don't even see, you know, it's not a normal activity. It's just nude children, and the grand jurors applied their common sense to it and said that these were lewd, and we asked the court to reinstate these indictments.
Let me ask you,
quick
do you
question,
think if the grand jurors had been told where they came from, they would have concluded as well that they were lewd?
Yes, I do, Your Honor, having looked at them.
Can I just, you're saying that these children would be embarrassed to know that these were, they don't know that they're in a magazine already? I don't know, I'm not sure I quite understand your point. You probably have.
Well, the question as I interpret it was, am I saying that none of them were exploited?
Right.
And I'm saying, no, I don't know that for a fact, because how can a little child necessarily agree that they're being posed for this picture and then the picture is going to be, you know, available? It's outside their realm of control.
All right, thank you very much.
Thank you, Your Honors.